Every country has a parliament and it has a constitution as a legislative framework to legislate for the affairs of the people and to hold the executives accountable. Hello and welcome. My name is Blessed Abraham, and today I'm presenting to assist in to increase awareness and appreciation of the Australian legal system, the system of government and democracy in Australia, changing focus to assist new arrivals in Australia on their constitutional obligations and to also get to know around, put their head around on the issues of governance here in Australia. And as I mentioned earlier, that every country has parliament and has constitution and has key institutions as part of that democracy. So I will begin with the constitution mindset that Australia has, and then I'll move on to the parliamentary mindset as well. So, for Australia to be a functional democracy, would require legislative authority. And this is a question of how that should, in fact, play out in constitution. So, and we also remember that culture and traditions of the people also been reflected in most of our constitutions. So Australian constitution has been based on the Westminster system. So you remember that Australia has been a colony of uh, the English settlement. And so because of that, the English laws had to find expression in Australia as well. So the establishment of that Australian Constitution also led to the establishment of Australia as a federation. So, what is the parliament mindset of the Australian government? First, let us look at the historical origin and development of Australian Parliament, because for us to understand a concept, we need to understand the context of the concept. So the historical origin and development of Australian Parliament can be traced or understood in a context of the older practices and values as held by the older parliaments. So, for example, um, in France, you find the word parler, which means talk or to be talking. And you also find ecclesia, which is a word often used in the Bible to refer to the assembly. And this word originates from the Greek parameters of interaction. And when you come to the Great Britain, you find the word like Magna Carta, which is actually basically same as ecclesia or parlor or a council of elders in a sense of those terms. So they are the words that reflect or echo the assembly presentation and the making of laws as may have been used by the older parliaments. So the English parliament reflects practices of the older parliament, as do Australian parliament as well. So in Australia, the parliament has two chambers. We have the Senate and we have the House of Representatives. So while the Prime Minister leads the government, the Governor General represents the Queen. But this is at a nominal level, and he performs ceremonial functions in that regard. So now let's move to the what are the roles and functions of Australian parliaments today? One of the functions is that Australian Parliament makes laws and passes laws through, and this power is provided in the Australian Constitution. Though the Australian Parliament does not have time to debate all the necessary laws, so it set aside what they call delegation authority. So this is to say that they delegate part of the decision making to the executives, and then the executives will go ahead and delegate. So the delegation power is contained in the Australian Constitution and allows those who the administrators of the relevant acts to establish subordinate laws to help with the administration. So the Australian Parliament also has a function to repeal the act through some parliamentary processes, and this is based on the parliamentary sovereignty, which I'll cover hereinafter. So they have a function to scrutinize the bills through a standing committee of the parliament, and the function of the standing committee of the parliament is to report on the appropriateness of the empowering legislation. So, what are the key institutions? We've already mentioned, already made a few comments in light of the parliament, and I also touched on the executives. But now we'll have to look at the key institutions, being the executive and the judiciary and the legislative as well. So, these are the recognizable divisions of power. The legislature or legislative enacts laws, the executive implements them, the judiciary interprets them to determine whether they apply in specific circumstances. It is also important to note two sources of law. So we've got the primary source and we've got the secondary source of law. So in Australia, the source of law, like I've already hinted to, is the Parliament. But in Great Britain, the source of law is the Queen. So under primary source of law, we have legislation, we have case law, and legislation is made in Parliament by the executive. When bill is introduced to the Parliament, it goes through a process of first reading, second reading, and third reading, and then finally assented to by Governor General upon passing in Parliament. So, and we've got the rules as well and the instrument concerning the governing of the state that also emanate from the making of laws in Parliament. And under the case law, we have courts and the function of courts. As we all know, courts are attached to judges. They're judges that sit in court to decide the cases. And so when judges make decisions, they rely on common law, they rely on legal precedents, they rely on legal history in order to inform their decisions. So courts also have the capacity to make case law. So let's say because they've looked at a certain legal precedents and they found that there's not any similarity to the current facts before the court in a different case, then the court can make determination, and within that determination, they can decide either to make a law a different case law or based on the circumstances, can also come to a different conclusion as well. So one key difference is that case law is from the decisions of judges in court, and while Parliament made law is from the executives. And so let's also look at the rationales and realities of separation of powers at the state and commonwealth level. It is important to note that there is no strict separation of power, but we can say that Chapter 3 of the Australian Constitution is the strict application of the doctrine of separation of power. So at the federal level, the strict separation of judiciary from the two other branches of government is evident. And the High Court of Australia have always been clear on this. And that clarity can be seen in the case of Wheat, 1915, and the Waterside Workers case, 1915. But the primary case is the Boilermakers case. In that case, we can characterize the judicial power and its application. So therefore, there is at this federal level strict recognition of judicial power. That means at the federal level, there is strict application of the separation of power. So it is also important to note that states do not have strict separation of powers. So only at the federal level, the judicial power of separation exists. It does not exist at the state level. And the primary authority to this proposition is a case of Cabal, Kabl. Now let's move on to the limitations on the parliamentary sovereignty at state and commonwealth level. So we're having looked at the rationales. Now we'll move on to look at the limitations on parliamentary sovereignty at state and commonwealth level. So elsewhere, it's not possible for a parliament to limit another parliament. However, this may not be the case for Australia's parliament. Australia is federal, which it is bound by its provisions. So it has a federal constitution, and by the provisions of that constitution, it is bound. So, and there are provisions that respect the provisions as enshrined in that constitution also reflects or provides that the continuing existence of the states and their laws must be respected. So Australia's federal constitution limits the sovereignty of the Australian federal parliament. This implies that the Australian parliament is limited by the content of laws, it's limited by the content of laws it can make. There are provisions in the Constitution also about what the Australian Parliament can and cannot do in respect to its sovereignty. Therefore, federal parliament cannot make laws in a way that it will bind state parliaments unless specified by the Constitution of the Commonwealth. They can and will not at any point in time be able to limit the state parliaments. So furthermore, federal parliament can make laws that can coexist with the laws of the state. So if the Commonwealth law is intended to cover the field, both the state and Commonwealth can operate simultaneously. If any part, however, or whole of the state law is inconsistent with the Commonwealth law, the Commonwealth law will always prevail. So the state's law, however, shall, to the extent of its inconsistency, become inoperative. A primary authority dealing with the issue of conflict between the federal and the state legislation is the case of Momcilovic. In that case, Mr. Momcilovic was given maximum penalty for trafficking meth. Meanwhile, the same offense. So that is the same offense was recognized under the Commonwealth Criminal Code. And the problem for the High Court when the convicted criminal was tried to overturn his sentence was the Victorian law was inconsistent. Okay, the issue was whether the Victorian state law was inconsistent with the Commonwealth law, and the court found no inconsistency. So the Victorian legislation and the Commonwealth legislation had to operate simultaneously together. That means that the High Court rejected to overturn the previous findings by the Court of Victoria. And that brings us to the end of the presentation, ladies and gentlemen, on the Parliament. My name is Blessed Abraham. Bye-bye.